2016 together with me to talk about the Panama Papers and, of course, the WikiLeaks and all that stuff. That was 1 month prior to the final rule coming out. In May 11, 2016, the government issues the CDD final rule. In July, just 1.5 months shy after that, our FIBA's BSA Compliance Committee issues a quick survey to our member institutions. The survey had 2 questions. In regards to CDD, does your bank currently identify persons who own 25 or 10% ownership? And number 2, if you reply to the above 10%, and with the CDD final rule made public, is your financial institution considering adjusting to 25%, yes or no? Here are the replies. Out of the 23 banks that were queried, 21 banks replied as follows. The bulk, which is 13 financial institutions, or 62%, replied that they're staying at 10%. 6 of the financial institutions, or 29%, were considering a blend between 10 and 25, and then 2 or 10% will stay at 25. The interesting factor with our survey was that the last 2 are 2 of the largest financial institutions in the United States. In August of 2016, the FIBA BSA AML committee presented a webinar with OCC, Fed, FDIC, and state examiners to talk specifically about CDD. And I remember from that panel, we went, I think it was an hour and a half, talking to them, asking questions about the things that financial institutions right now consider an issue or having concerns and things about CDD. Finally, in October, just last month, October the 18th, the BSA Compliance Officers Committee had a meeting to discuss CDD and how it's affecting us directly. That was a more private and intimate group. But some takeaways from that are obviously complex structures and ownership. Now we bring this panel to address a summary of all the information gathering and all the stuff that's going on. We will continue to tackle CDD in December, where we would have another panel to talk about foreign correspondent banking and how it's affecting that as well. We will also tackle the CDD final rule with the examiners and lawmakers from Washington during our AML conference in March of next year. So without further ado, and again, sorry for the wait, I want to introduce to you our 2 speakers. First, to the far right, Kathy Conilly. Kathy is a partner with DLA Piper. She serves as the chair of civil and criminal tax litigation in the firm's global tax group. Before joining DLA Piper, Kathy served as the Assistant Attorney General for the Tax Division of the U.S. Department of Justice, where she oversaw the work of over 350 attorneys in civil, criminal, and appellate tax litigation nationwide. Mike Silva is the next speaker today. Mike is a partner with DLA Piper. He focuses his practice on international tax law with emphasis on U.S. investment structures, cross-border tax issues, tax treaty planning, withholding obligations of U.S. real property investments, and U.S. activities of foreign banks. He has significant experience providing counsel in connection with the Foreign Account Tax Compliance Act, FATCA, a complex unilateral U.S. tax legislation that imposes third-party reporting obligations on global financial entities. So welcome both Kathy and Mike, and the panel is all yours. Kathy, go ahead, please.
Thank you. I'm happy to be here. It's always good to talk to this group. I'm going to start by giving what was the government perspective during my tenure and what I know continues to be the government perspective on information gathering. Given that we've lost a little bit of time, I'm going to go through this part a little bit quickly and then get into the meat of what our program is. Let Mike and Danny do some of that. Can we move the slides, I guess? I'm just going to cover the first 2, what are slides 2 and 3, quickly. maybe we're not moving the slides in the room, but to do this fairly quickly, I mean, everyone in this, I'm sorry? I'll keep going. If you saw the slides, they would be a list of what you know are some of the government's enforcement efforts over the last several years, and they touch on financial institutions. They are more directly aimed at account holders. Obviously, the IRS's offshore voluntary compliance program, which has now crossed $10 billion in money coming in from previously unreported bank accounts. FATCA, the Justice Department's Swiss bank compliance program, which crossed $1 billion in bringing in Swiss banks that had issues that I think go beyond the kinds of issues we're talking about here, issues where the government's view was that the banks were aiding and abetting tax evasion in the United States. The one thing I want to pause on, because I actually did a panel program 2 weeks ago at the International Tax Enforcement Conference, and one of the things that we talked about was the way in which the increasing criminal enforcement here and Europe, globally, is affecting the way everyone thinks and looks at these issues. And when we talk about information gathering, we are very much talking about information gathering to stop all of that non-compliance effort by account holders and now on a global basis and with global cooperation. I'm not here particularly to say scary things, but I am here to acknowledge the mindset sometimes of the government in this area and a little bit of what you're dealing with. So, you know, we'll talk as we go forward about how you comply with the actual rules that are there, but also how you be ready to respond when the government asks questions. We should by now be, if we could switch to, yes, actually slide 3. Again, this is basically a list of the things the government has been doing in terms of information gathering. And when you talk about CDD, and when you talk about the other issues we're going to address today, the GTOs and all of that, you are talking about the next steps in information gathering. You're talking about Treasury and the Department of Justice, the IRS, over the last 8-9 years now, learning more and more and more about what's being done to evade taxes and looking at how to, through disclosure up front, get at that information, and how to, through enforcement activity, get at that information. So if we could be on slide 3 or not. You know, there are some traditional things like the treaties and MLATs and other cooperation between governments, summonses, grand jury subpoenas, but there's 2 that I want to highlight here, and then it will feed into something I know Mike wants to talk about. The government is looking increasingly, and this is no surprise to anybody listening, increasingly to financial institutions to provide that information. And on the enforcement front, the interesting tool that that the government has realized has great utility are summonses to banks in the United States for correspondent account records that are in the United States. So over the, and this took hold, honestly, during my tenure. The IRS and the Department of Justice realized that while we were facing bank secrecy issues in other countries and data protection laws in other countries, that the United States does not have similar protections for those kinds of records, and that for the correspondent account records, they're here. And so if you have an account in a bank secrecy jurisdiction or in a country with better data protection than the United States, but the transactions get done in US dollars, or the account holder needs for some reason to engage in a transaction in the United States and moves the money through a correspondent account here, there is a wealth of information there. The other, we seem to be one slide off from where I want to be, but the other point that I want to make here before Mike picks up on the Pichincha case is the government's recent use, particularly in a tax case, of a Bank of Nova Scotia subpoena. Now, I don't know in the room or people listening in how many people are that familiar with a Bank of Nova Scotia subpoena. It is, I think, one of the arguably controversial and somewhat from an analysis point of view complicated tools that the government has. A Bank of Nova, what happened in the original Bank of Nova Scotia case and in a series of cases that came out around the same time was that the government here, the United States, issued a subpoena to a branch bank in the United States and for records that were not here, for records that were in the Caribbean, in bank secrecy countries, and records that were in European bank secrecy countries, such as Switzerland. And the court there wrestled with the question of, can you make the entity in the United States responsible for getting the records from the foreign branch? Or the foreign parent, but can you make the entity of the United States responsible for bringing those records to the United States by subpoenaing the entity here? And what the court said was that it is a balancing test between the interests of the U.S. government and the interests of the foreign government in its law, and because you're putting the entity between the rock and hard place of the laws of two countries, and complying with the subpoena here or complying with the law in the other country. And in doing that balancing test, the court came to the conclusion that the court should give tremendous deference to the United States government for already having done that balancing test when it chose to issue the subpoena in the first instance. That if the State Department or the Justice Department or the Treasury Department had concerns about the issuance of that subpoena for the comity interests with the other country, that they should have resolved that before they issued the subpoena, and that the courts weren't going to second guess that decision. So the outcome from the legal analysis of the Bank of Nova Scotia decision was that there's been a general assumption that if the government issues that kind of subpoena, and it's called a Bank of Nova Scotia subpoena because Bank of Nova Scotia was the bank involved in the case. If the government issues that kind of a subpoena, that the court will enforce it. But what happened when the courts started to enforce those subpoenas is that the banks said, no, we're not going to violate the law of our home country, or we simply can't, that the records aren't here and we can't get them here. And what the courts then did were impose sanctions. And the sanctions were intended to be compelling, for want of a better word, that the sanctions would be so high, monetary sanctions, that the cost would be so high that the bank would capitulate. And I take this case personally on two fronts. I actually started as a young lawyer at a firm that had represented Mark Rich and Company, which was the subject of one of these court enforcements. And at one point when we were moving our offices, we actually located the check register where the $50,000 a day payments had been made in resistance to this. But the other place where I take it seriously is it was something I needed to consider in the government. And it was something we were weighing during my tenure, whether to issue Bank of Nova Scotia subpoenas. And part of what the analysis is, in addition to whether you are going to say that the laws of the United States and its desire to get those records should outweigh the laws of another country. The other piece of that analysis is it going to get you anywhere? Because if all you're going to get is a pile of money and you're not going to get the records, what have you done? You've disrupted this relationship with another country. You've put this entity between a rock and a hard place, and you haven't accomplished the thing you want, which is to get the records. And you know, I will say this is part of why, with the Swiss banks, we went into the negotiations with the Swiss bank program to avoid having to make any other kinds of decisions there. And this is why you haven't seen these subpoenas in a long time, except recently. And this is why I want to just bring this out today before we move on to the Pichincha discussion, because this matters. Recently, the Department of Justice issued a subpoena to UBS. It was a Bank of Nova Scotia subpoena. They issued it to UBS in the United States for records in Singapore, which is a bank secrecy country, and a country with which we do not have a treaty for mutual exchange of this kind of information. And UBS complied. They didn't even wait for a court order. They simply complied. And this tells me two things: that the government is going to be brushing off this tool and thinking about other ways that the government can use it, that they're looking at it, and I know it has been something that everybody's been discussing for a while, but that they're thinking about effective ways to use it. And that one of the things that they're thinking is that in this world of increased transparency and increased compliance, at least some banks will comply, and that this is a decision that financial institutions will be asked to make. And at least the one public case that we know about, UBS simply complied. So with that, I think
here we got the slides, and I think it's a good time, Mike, to talk about perhaps Pichincha, right?
Yeah, I think.
Lead on to that, the Pichincha case, and you know the efforts that I know that FIBA has done for the past years. Mike, go ahead.
Sure. Pichincha is a very important case.
Which in my deck should put us on slide 4, by the way. Oh, okay. Good. I can.
Go ahead.
And on slide 4, we'll see that we're discussing the.
No, the slides got out of order.
It's okay.
Yeah.
So I will start out by discussing that the Pichincha case in many ways demonstrates what banks have to grapple with, which is the perception that they need to comply with the court order, but that there's the practicality of, one, having the records, and number 2, having control or access to the records. And if they need to access it from a branch or a different division of the firm, can those persons that are holding the information disclose it, because they've got something called local laws. And it's important, you know, that we recognize that in the U.S. judicial system, it's a well-recognized, understood area that the courts expect even parties that aren't involved in the litigation, third parties that might not have anything to do with the underlying dispute between two other parties, the third party, if they have anything that furthers in the evidence process to get to the truth of the underlying dispute between two different parties, then they can be burdened by a court through third-party subpoena and be asked. And that's just a judicial understood concept in the U.S. that doesn't always apply across the rest of the world. But we are now having the rest of the world work in a context of global transparency and more information sharing. So just as a quick overview, remember, we've got the G20 meeting, and in 2010 they met and they said the world of bank secrecy as we know it will end, and there will be more transparency and more ultimate beneficial owner disclosures. We have FATCA and CRS, FATCA from the US side and the OECD CRS side, noting that FATCA basically started after being passed in 2010 by both sides of the US Congress, and invoking information sharing starting in 2015, and we have the OECD starting in 17 and 18. There's a huge amount of movement in the compliance world right now to be prepared for this. And we also have FinCEN taking up almost a reaction to Panama Papers and leaks that are out of Luxembourg and other important jurisdictions. And all of this is happening during a time when, because of the inconsistency with CRS and FATCA, because the U.S. being the author of FATCA and the Treasury has not signed on to CRS, so there's a perception that there's some inconsistencies and that the U.S. now is receiving funds that had been parked in other parts of the world in traditional banking centers. Whether the U.S. is a tax haven or not is a debate, but there is movements, and this all causes FinCEN, another division of the U.S. Treasury, to react. So they've done geographic targeting orders, customer due diligence that we want to reserve our time for today, and also a proposed Treasury reg that has to do with the fact that while the U.S. and the OECD is talking about multiple jurisdictions and nice places where perhaps tax rates are zero and it's easy to form a holding company in the Caribbean or other parts of the world, there are many U.S. states that allow you to form an LLC or another type of company without any database disclosure as to the ultimate owners. So places like Delaware, Wyoming, South Dakota, on and on. And in reaction to that, a certain section was adopted, 6038 Cap A, that proposes having mandatory disclosures of entities like LLCs with a single owner, even if they have no tax identity, no tax status. So these are all things in reactions to FinCEN and the type of world we live in. And then, of course, we have the world of the Chevron case that's world famous and is dealing with just, you know, billions and billions of damages. But the Banco de Pichincha and its branch here in South Florida was deemed by the judge to have proper possession, custody, or control. In other words, if you can get to this information, I believe you can get to this, and therefore you have a duty, even though you're not involved in the underlying dispute between Chevron and plaintiffs, you need to get a hold of that. And they challenged it. They said, no, we don't have access to that. And in Miami, we're a mere branch. We don't tell the headquarters what to do. They're the headquarters. And it's in a secrecy jurisdiction that needs to comply with their own local rules, and we can't violate those rules. The court didn't see it that way and came down and basically said, you must disclose the documents, and it was appealed. And FIBA took an active role noticing this, that it would create a certain chilling effect for new business, new branches coming to Miami, and took up a role to say, is the law right, or the facts isolated and shouldn't apply and make bad law, so to speak. And therefore, the general counsel for FIBA and various committees took on a role that involved speaking to the legislature in Tallahassee to get a positive result. And without any more ado about Pichincha, there is a positive result. So things are better than they used to be after Pichincha. And it was legislatively, the decision in Pichincha was legislatively modified. So one of the things that might distinguish Pichincha, which were private parties, and the Nova Scotia is Nova Scotia, we had the government as one of the parties trying to get the information. Pichincha were just two private parties fighting over money. So that may be the reason why the courts saw the whole control and custody type analysis in the Balancing Act that Kathy was mentioning a little differently. So Panama Papers clearly, you know, brought us to a world where the U.S. government was trying to react and say, how do we handle the fact that the U.S. has a very open door policy and welcomes foreign investments from around the world? Since the financial crisis, foreign investment in U.S. real estate projects and development, U.S. portfolio stocks, the amount of U.S. treasuries that are sold to foreign investors, Chinese, Japanese, and others, is a very, very important thing. And it encourages all these positive things like stable political environment and so forth.
Mike, and to stop you there and to intervene, because this is at the heart of our financial institution members, it's also, you know, all this stuff about what attracts foreign investors to the United States to purchase condos, to invest in companies here, it has been a challenge for us, and I know we're going to get to talk about CDD in a couple of minutes, but it has challenged our financial institutions perhaps to redefine a couple of things. Number one is NRA accounts. And we've said it over and over again during our courses here at FIBA. Sometimes your bank or your financial institution says, look, I don't have any foreign accounts. I've got LLCs that are local here. But when you look at that ownership structure, you're going to find out that it's not a local account. It's owned by a couple of structures that are offshore. It perhaps the ultimate beneficial owner is not even a U.S. person, and it's a foreign investor. And so it kind of has redefined our work in the financial field to look at our portfolios, number one, and number two. With the CDD final rule, one of the challenges that our group here and folks online have brought to our attention at FIBA is how do we work those complex structures in, and how do we deal with that? So just a thought, that is at the heart of the people who are here today and who are listening to us. So let's talk a little bit about that.
I want to just echo that in a very straightforward way, briefly. And this slide that's up there right now shows a cover of New York Magazine from June of 2014. When I was at the government, we were focused on banks outside the United States that were facilitating U.S. tax evasion. That cover of New York Magazine is literally the one that was on my doorstep when I left the government and came home, because I'm a New Yorker. And what it is saying is that the next phase of enforcement will be non-U.S. persons who are using U.S. facilities, whether it's LLCs or whether it's real estate investments or any of that the rest of the world is now turning back to the United States and saying, you've pounded on our banks and our facilities for tax evasion in the United States. You are similarly at risk for the use of U.S. facilities, rather than call us a tax haven country, but that is what the rest of the world is calling us. And that is where enforcement is going. And that is the unifying theme of all of the rules that Mike is about to talk about. And then some of the enforcement I'm going to talk about again at the end.
So recent enforcement measures. We have to remember that when private bankers are dealing with clientele and there's structures that are coming in besides the non-resident alien account, that the U.S. is not a tax-neutral jurisdiction. It has tax advantage treatment for foreign persons to invest in the U.S. Not so much in the area of real estate, but in portfolio securities, other investments on Wall Street. They're very well treated. A lot of exemptions for capital gains on trading of securities, portfolio notes, whether it's Ford Motor Credit, bonds, or U.S. Treasury bonds. There's no tax on the interest earned on those amounts. And it's generally considered that these incentives drive the credit markets, make liquidity easy, encourage employment in the U.S., and international banking is facilitated with these favorable treatments. Other countries have similar welcoming incentives for foreign investment. But is anything more than a non-resident alien account when there's an LLC or a trust and something more exotic involved and put in front of the private banker? Why is it? And there was a time when, the U.S. government really didn't need to know, didn't want to know, like, why did you capitalize this company with debt versus equity? And the banker would say, why do you need to know this? That's, whether they can afford to purchase the underlying investment out of their own pocket, cash, or what lending, in leverage is not driving the underlying AML and KYC rules and Bank Secrecy Act rules. But I think the world is changing very quickly, that there's an expectation with the CDD rules, which are enhanced due diligence rules. In other words, we've already have the entire U.S. Patriot Act, KYC, Bank Secrecy Act, keep going. But now we're increasing this, and why? It is reactive. There's proposals even before Panama Papers, but it's accelerating because of Panama Papers. And they want private bankers, in my view, to understand the structures and know why, and to say, is this a legitimate business reason for having a trust in an LLC and a foreign company in between the trust and a Delaware LLC, and for you to have a working knowledge about why each of those entities are involved in the structure for the underlying account, and to know who the account owners are. So that's what CDD has to deal with, and entity-owned financial accounts are a focus of the CDD rules, because up until the CDD enhanced due diligence, technically the regulatory environment was get to know your customer. You have to know a lot about your customer. What's really happening now is you need to know your customer's customer. And that is a landmark change in the attitude, and I think it'll trickle down to enforcement eventually. But we also have these GTOs, which reflects about cash being moved around, purchasing real estate through vehicles where the ultimate owner identity is masked in some way. So is there a reason for the anonymity or the privacy? Why buy that New York Time Warner condominium for $17 million through an LLC? Why not buy it in individual name? And of course, you know, estate planners and others would say, look, there are legitimate business reasons for buying properties through entities besides some nefarious underlying keeping the identity of the owner secret or something like that, or the source of the funds. There is a U.S. inheritance tax that applies to foreign investors that pass away. Usually, although persons have an expiration date, companies don't necessarily have an expiration date. And trusts don't necessarily have an expiration date. So the use of these vehicles can be beneficial and have legitimate reasons for simple estate planning. Inheritance, do you need to go through the courts if someone expires and then the children come in to inherit? Or does a trust serve as a substitute, an efficient substitute to accomplish your client's goals? Are there reasons like limiting liability? We're in the U.S. where someone slips and falls on your property, and did you have enough lighting, or did you clear the ice out before you have a personal injury claim or a plaintiff's lawyer coming against your property and the property owner? Another reason why any corporate lawyer would advise any hotel, any business investment and so forth should be held through an LLC.
Mike and I have always had this discussion about doing a panel where, you know, he explains all these right reasons why someone would go through a complex structure. However, I want to point this out. Prior to coming here online, Mike shared with me that one of his prior panels was called "It Takes How Long to Open Up an Account?" Okay? So, and here's the deal. The CDD final rule now calls us, the financial institutions, to go through the motions and find out that beneficial owner prior to that account to be open. So when you have, you know, for estate planning and for, you know, all these reasons that Mike is giving, which are absolutely correct, you know, there are tax reasons and benefits that are out there, but when we're called for, the financial institutions, to comply with CDD, to know that beneficial owner, 25% or more, which is the final rule, or if not, we will be in violation of that rule. That is a challenge. And Mike, I want to, you know, throw it back at you. You know, from the name of that panel, that sounds like you're right on track.
Sure.
To where we are saying, wait a second, these are problems and these are things that we're discussing, and time is running out. Go ahead.
Sure. Well, in the interest of time today, it's important that we also mention that FinCEN is reacting with targeting orders for institutions that, of course, have to know everything about your customer and your customer's customer for any all-cash deals. And this is now even extended to title companies that have been receiving cash transactions for purchases of underlying real estate. So in the interest of time, we're going to fly through a couple of slides, but I want you to know in your materials, which are going to be available to you, The GTOs are looking at beneficial owners that have 25% or more of an entity. And if that entity or the LLC is buying underlying real estate through cash, there are thresholds now that require even non-banks, title insurance companies that are worried really about title, not money laundering. That's not their training. That's not their exercise. What they're selling is title insurance for real estate. They're now required to get information and on the source of the funds and so forth, bank-like exercises. So it's important to note, and of course there's a lot of rules here, the all cash purchasing of high-end real estate in various boroughs, including Manhattan, LA, San Francisco, San Diego, and San Antonio were targeted. They have different thresholds for when these rules kick in. The dollar amounts are set forth here, and it's important to see whether this is an expansion or not. On page 14, we have, and around page 14, we have these thresholds and so forth. So without further delay, let me get to the CDD rules, the enhanced rules put out by FinCEN. It's very important that the goal here now, since the rules were put out in May of 2016, is to expand on the bank secrecy and to clarify. The government's viewpoint is we're not burdening you that much because you've already had to do these things. What we're doing is we're filling in some extra details, and we're putting out this 25% or more of any legal entity standard that requires that you not only obtain but verify information on new, it's prospective rules, on new accounts if an individual owns either directly or indirectly an artificial entity that opens an account with you. So partnership, trust, LLC, or a regular corporation, that's all included. There's a list of the exempt entities that I'll go through, but if there's an ownership of 25% or more, you need to get information related to that owner. There's also a corollary because, of course, you know, it would take a very simple, you know, artful lawyer to say, oh, we're going to have 5 investors, and they all have 20%. We're under the 25 threshold. So there's a corollary rule that says, regardless of the 25% or more rule, there's also a who has control or substantial control to make decisions over that entity. That's the other prong of this test where you have to obtain information. So it's very important that when you're opening an account, onboarding, and that goes back to my title, it takes how long, you have to understand that artificial entity and who's going to have control. Maybe there's a value of one owner has, maybe a parent has 99%, but they're bringing a child to get involved in the enterprise or the entity and so forth, so they're going to give them a 1%. Okay, but eventually they have more vote and they have control, even though the economics are split in a certain way. So you need to kind of understand that. And it's very hard to give one definitive rule because of this standard.
And Mike, there's already a question out there from one of our committee members. Okay, let's ask this, and both Kathy and you can tackle it. What do you think would be a bank's expectation, or perhaps from a regulator or from an attorney suggestion, when the controlled party is not disclosed? Okay, so I'll give you an example. You are opening up an account for a large multinational in Latin America. You're opening up an account for them, and you've gotten all their beneficial owners, but you've got to hit that control. You've got to fill that control prong. And the president of that large corporation, or the person who on the day-to-day has control, says, wait a second, I don't want to bank with your bank. I've got an account with my bank in New York for 25 years, and I'm not going to have a relationship with this financial institution, and there's a rejection. What would you suggest our member banks to do if that comes along our way?
Well, our member banks, and this rule applies to covered financial institutions, which includes broker-dealers. So that division of your bank
Correct.
needs to be involved in this also. And it's a broad definition, but to answer your question, anyone with significant responsibility, that's the buzzword, that's the standard that the regulators are going to say. Significant responsibility, control, manage, or direct such an entity. Someone with the power of attorney may not have any ownership. They may be like the country manager or the local manager for the entity or the family. If the organizational documents allow or require for any transfer over 50,000 or 100,000, that there needs to be a super majority. So not just the person that has significant responsibility, but all of the owners for any transaction over 100,000 need to sign off. Then all those persons have. Those persons may have under 25%, but as to this transfer under the organizational documents and the account opening documents, anything over, just like a dual signatory account, you need both signatures to do anything. The organizational documents for the company may require unanimity, so everyone needs to be known about. And what's the type of information you need to collect? The beneficial owner's name, date of birth, address, social security number or foreign identification number, if there's a passport number, and the country of the issuance. Those are the same sort of things that we would expect. But there's a really important standard here of significant responsibility for controlling or managing the legal entity that I think means anyone that has the ability to say things and to do things. So if you understand that there are these persons, but there's an undisclosed person with the power of attorney that is copied on an email, and you see them saying, signed off, okay, and so forth. That okay email, you may not know that person yet, but you better get to know them, because that would be significant responsibility to control and make decisions.
The incredibly simplistic way that I have described it to people is, if you can call a guy who can call a guy who can make something happen, then you have control. If everybody in that chain is going to do what you say or ask you before they do it, you've got control. And I think from a regulator enforcement point of view, if you've got the obligation to find out, as Mike has described, the obvious places of control, and you have the obligation not to turn away from what you see happening in terms of the email example and all of that. Obviously, if they don't tell you because they're hiding it, that's one thing. But if you haven't asked, or if you've seen it but you've looked away, that's going to have a different reaction from the government.
Kathy, thank you. I think right now we've got, and I'm going to go ahead and open it up for some questions, okay? This is the topic that really has our banks moving along. So Yanira has a mic. Whoever has a question ready, please. And here, give us just a second for the question.
Thank you. Hello? I don't think it's working. It's working? Okay. My question is regarding the collection of data on the control prong. And as would be expected, most international banks deal with PICs and trust structures that are managed. And when I say managed, I'm talking about corporate officers, maybe nominee directors and so forth, that work on behalf of major financial institutions, and they're representing the account in a corporate capacity. They provide an ID, but we know many IDs, including passports of foreign countries, do not have an address. And when we have reached out to collect an address, they refuse to provide an address because they say, I'm acting in a corporate capacity. I am not requesting a personal account. Therefore, I will give you the address of the corporate office I'm representing, but not my residential address. So we've had a few of those cases, and I'm talking about major financial institutions where, as of today, I don't know if when, come May 2018, this is going to create a standard globally, but I tell you, we've gotten a lot of pushback and resistance from the nominee directors on some of our managed trust on providing a personal address other than the corporate office that they represent for that structure.
Before you answer, Mike, just to address the part of nominee shareholder, nominee director, nominee officer, because we've seen that a lot. And we tackled that through the BSA AML committee. We worked with the Legal and Regulatory Affairs Committee at FIBA to produce a kind of an affidavit that will help us. And that affidavit says, if you're the nominee shareholder, list your name, but we also want the name of the person who's appointing this nominee shareholder. And it also gives us a section for the owner of the company who's appointed that nominee director shareholder to disclose why do they need a nominee shareholder and director. And so with that information, and perhaps we can work offline and I can try and share that information with you, we can tackle your concerns on nominee, but I'll open it up to Mike and Kathy about your other concern about that reaction that you're having with your customers.
Well, the record retention under enhanced due diligence is for 5 years, by the way. So whatever you're collecting and how you're collecting, it's important. And as an aside, by the way, the FATCA classification for the entity and so forth, the address, whether it's a U.S. address or a PO, there's a series of rules there, and they don't like U.S. addresses, hold mail, and PO has to be explained away with an attachment to the W-8 bin. So I see you're nodding, and it's good that we know those peripheral issues that could arise. But to answer your question, there is a requirement that one individual, at least one individual associated with the persons that have the control and the supervision must be identified. And it's not clear whether their home address needs to be provided. They're an individual, but they want a beating heart, is the way I read those rules. They want a beating heart. And a beating heart means someone they can call up or knock on the door or find somewhere. So, you know, there's a lot of public perception. The media has played a role in this, you know, the service providers of the world, which provide a very valuable service informing companies like the Tridents and the TMFs and the AmiCorps of the world. But you also have these databases for efficiency where they, you know, offer nominee services, and there is a corporate address. And of course, somebody in the media does some, you know, sensational news report, and they go and knock on the door of some building in the Cayman Islands, and there's 900 companies registered there, but the door's locked, and no one's coming and going. So that feeds in itself, just like the idea that why do you have an LLC in a trust structure for a client? Government examiners may say, oh, it's to mask identity. There must be something here. The estate planner says it's inheritance, it's estate planning, it's estate tax, the simple concepts of what anyone with wealth would do. So there's this perception and the reality, and the bank is put in the position of having to find legitimate business reasons. I think the world of saying whether our entity is capitalized with debt or equity, whether the father wants his children to get involved and he's giving them, you know, perhaps non-voting interests, economic interests, and so forth. Those are things right beyond. Now the examiners, I believe, with these enhanced due diligence rules will say, but you understand why, right? You understand, and that those reasons why, the filled in blanks that Daniel was just describing, created a reasonable reply for you to feel good about proceeding and having that account in place. If you don't feel good, then it goes into a risk-based type analysis where you need to ask for more information, examine it.
I think we had one more question here. Danita, if you can have the mic. One more question around for the panelists. Thank you.
Just a question. You hear me? I think you clarified now, but at first you had said that, you know, the controlling persons, we need to know everybody. From what I understand on the rule is you need to know one controlling person, and that's how it's supposed to be.
At least one, yes.
Right. Okay. So not everybody. There could be 50 people that control you. You're only required to get one person.
At least one. And if next to their name says CEO, great. You know, that gives you a perception, an outward manifestation that someone is able to make a decision when they have a title of CEO. If it's assistant to an assistant secretary, perhaps you need to ask for somebody else that's more in control.
Let me address with that one more, and Kathy, this one's for you, okay? You worked for years in the government with the IRS. So here's one that comes as well from our committee members, and you saw the results from our survey. 2 of the major banks in the United States are keeping at 25%. Some other financial institutions, we're thinking, well, I'm at 10. What do I do? Okay, the competitors there, you know, across the street are at 25. If I'm at 10 right now, what would the government's perception be if come May 2018, my financial institution decides to go up to 25%? And what are your thoughts on that?
Danny asked this question just before we went live. So, and it's, I mean, I think it's a hard question. And I want to sort of build on the things Mike said, because I think he hit everything exactly right. That, that what the government is going to look at is, did you know why it was happening? He's absolutely right. If there is an explanation for what you saw and it made sense and it resonated and that's why you went forward. And one point I've wanted to make a couple of times, so I'm just going to make it right now, is I do not believe that the government, let me say it more affirmatively, I believe that the government does not adequately respect the role of confidentiality in all of this. You know, when we talked about real estate purchases, there are good reasons to buy real estate through a vehicle if you do not want people to know where you're living, if you're a high-profile person. You know, certainly when Mike mentioned the Time Warner building in New York, that's who's living there. And I've got sympathy for the corporate officer who does not want his personal information there. And we as a country do not respect data privacy in the way that other countries do, which I said earlier. And I think if you look at the purpose of what's going on, so in the question of why do you need the person's address, you need the person's address to know he's real and that you can find him. If that address is going to be you know, 900 businesses have that same address in Tortola or in the Cook Islands, then yeah, you probably need the home address because he can't be found there or she can't be found there. But you need, but the corporate address, if the corporate address is where you're going to find the person, should be adequate. And presumably if the person left the corporation, some other name would go there anyway, so that solution would be there. It's the same mindset on the 10% going up to 25%. I believe that the government does not always adequately respect competitive interests. That if all your competitors are fine at 25% and you were doing 10%, that it is harder for you to move forward in a 25% world. I would like to think that it is okay to then come within the rules and you're fine. I think the risk, and we talked about this, the ultimate risk in all of this is what happens when something has gone wrong. I mean, that's when the government is looking. The government is looking because something went wrong. And the something that went wrong can be that the customer lied and the information that you got was inadequate to have you do your due diligence correctly. Or it can be that your process in getting that information was inadequate. And you want to be able to show the government your process in getting that information was adequate. So if you're moving from the 10% to 25 because the law will now accept 25 and you were being more diligent, I think that needs to be in the context of showing that your diligence hasn't slacked off, that you're still knowing what the purposes were of the structures, you know, the know your customer and all the rest of it, that your systems are in place. Then I would like to think that that an acceptance that you function in a competitive world and you couldn't demand more once the government set a standard is acceptable. But if it's a whoopee, you go from 10 to 25 and you slack off in other ways, then I think that going from the 10 to 25 will be seen as a pattern of moving in a negative direction from the government's point of view. So the assumption that everybody who's paying attention today to this webinar wants to get it right, I think if you're being diligent about putting the rest of your systems in place correctly, that you should be able to go to 25.
And I could see a discussion in which the compliance people are doing the survey and they say, well, we like the fact that we're able to dig deeper and that should be perceived as a good thing. And then it gets disseminated and the private banker says, but I had my client complaining because he went down the street
Right.
and he said, we're making a hassle for him by asking for everybody with 10%, because our competitors just said, no, that's not the rule. That's just your competitive banker giving you a hard time. The rule's 25. We only need info on these couple of people, not everybody. You know, are you losing business? What's the competitive pressure? So there's this internal conflict. We've seen it for years, and it ebbs and flows. Sometimes the people bringing in the business demand, compliance, help them out, and then compliance pushes back, and you see compliance having lots more. I can say the trend has been in compliance departments having a lot more say in the operations. But it's really important that we also talk about the attitude of the government is one in which there is this global perception of whether the U.S. is being hypocritical in certain areas about entity disclosure and whether we're a tax haven or not. And the Treasury Secretary recently asked Congress to swiftly pass meaningful beneficial owner legislation so that to require companies, right, artificial entity accounts, which do not generally include private trusts, family trusts, and so forth, the partnerships, as I mentioned, LLCs, other type, or registered trusts. So in the U.S., registered trusts are like land trusts and things like that, certain business trusts, but not what private bankers would think about a will substitute, the trust between the parent and the kids and so forth. So they want to know the real person behind a company at the time of its creation. That's the standard. And this has to do with the proposal to mandate that states, there's no such thing as a U.S. corporation, right? We have 50 states that have state law. We have Delaware, Wyoming, Florida entities. There is no centralized database. There is not even consistency as to what needs to be submitted in order to form the company in Delaware versus Florida. Delaware is a little more minimalistic compared to Florida, actually, and some other states. There is a proposal by the current administration. Okay, we had an election, but the current administration did. The current administration runs out. Yes.
Yes.
So I'm saying that this may change, but the current administration did have a white paper and a White House proposal that FinCEN should establish a national database in all states through federalism, in a federal law, require that they dump the ultimate beneficial owner or some beating heart person with control and authority for that company into a database, and that FinCEN would manage that database. Then bankers would have perhaps a clean line to say, hey, we need to see this person. Maybe there's a silver lining in that sort of proposal. Then again, I could just imagine how it gets maintained, how long the website takes to get updated and so forth. But there was a proposal by the current administration.
We'll be looking for that in the next couple of months to see if it changes. We've got 10 minutes. And like I said earlier, this is a preview to 2 panels that we're having at the AML conference in March that will address not only information gathering, we'll go into more details, but the CDD final rule in depth. So Yanira, do we have some questions online? And if you want, let's use these 10 minutes that we've got so that the panelists can address some folks that are online that have questions. Go ahead.
We have one from Steve. He's asking, we are a commercial and consumer bank, and during a routine exam, we were recently asked by an examiner what, if anything, we're doing for due diligence around EB-5 immigrant investor customers. Have you heard of any FIs taking special actions for this customer type?
EB-5s, yes, very popular and utilized mostly by Asians, if you're counting the numbers, but also certain countries in Latin America where there's been limited immigration visas available to them. The project money has its own requirement, but usually the $500,000 amount that needs to be deposited does need to have the typical due diligence requirements. It needs to be examined. There's rules within the EB-5 that that money be their actual money that they're putting at risk. In other words, it not be a loan. However, families are families, you know, pay me when you can, and here's $500,000 for you to stay in the U.S. after your studies and so forth. The due diligence associated with it should be exactly the same thing with any other situation. That's a succinct answer.
Yes, and like you were saying, that those type of limitations, specifically in Asia, we've seen it also in several countries in Latin America for foreign currency, especially for U.S. dollars, also creates a challenge for our financial institutions, specifically in the EB-5. I think it's, correct me if I'm wrong, $50,000,
Yes,
something like that, for folks in Asia per year. That kind of creates us an issue because we are, especially in Latin America, and I've heard it from financial institutions in New York that handle Asian portfolios, creates kind of like structures that families or other investors set up, where you have multiple investors going up to the limits where they can invest, and questions have been rising whether if you find those patterns, if that's something suspicious or if that's something that the bank would need to look into. So we've discussed that as well. Danita, any further ones? Okay. We've got 5 minutes for wrap up. I want to ask right now, if you've got any questions, please, and let me get you the microphone. Give me 1 second. Thank you.
Yeah, thanks. Thank you for the presentation. It was very informative. I appreciate it. Thanks for FIBA for putting together the panel. But I had a question for Kathy more specifically. You've been in the government. You've been involved in this, but you mentioned in one of your early slides there's a perception of the U.S. being a tax haven. So can you a little bit elaborate on that? What is the government? I read the letter of Secretary Liu to Congress, but what is the government doing on this perception? Is it some sort of action? Especially because I've seen, and Mike mentioned some, creative lawyers playing with the rules. I've seen a number of FATCA-driven structures for non-U.S. people in which, as a financial institution, we look at it and we do the CDD, and it's like, well, how many U.S. people are here? And the answer is none. So, what is the reason for setting up a U.S. structure? And then they start to go on kind of not very clear answers. But the structure is legal, of course. It looks good, but I think that it ties in with FATCA and CRS and the differences, and there are people playing that hedging game.
I want to thank you. It's a good question, and I'm going to try to wrap up a number of themes from today in the answer. I think the threshold question was the perception that the United States is a tax haven country. I mean, the perception comes because the rest of the world is saying the United States is a tax haven country. One of the things that I did in my office was negotiate directly with the Swiss government on what became the Swiss bank program. And the United States as a tax haven country was a regular statement by the Swiss. We were saying to the Swiss, and we've said to other parts of the world, your banks are being used to facilitate U.S. tax evasion, and that they're doing it in compliance with local law, but in a conspiracy to violate U.S. law, and we're going to prosecute there. That is, without question, a statement of arrogance by this country to say we're going to prosecute your banks and your bankers for things they did that were legal in your country, but had an illegal effect here. I believe that there has been pressure on the United States to respond in kind to that. I mean, the slides we're not going to get to talk about the Pasquantino case, which is a case in which the U.S. government prosecuted here for activities that involve the evasion of Canadian taxes. And they did it under the money laundering statutes. They did it under mail fraud, wire fraud, and ultimately the money laundering statutes, not tax statutes, but ultimately those. And Pasquantino's been out there for a long time, and that is the law. And there is no question that you are seeing investigations now ramp up in that direction. And there is no question that when you look at the GTOs and you look at CDD, that is the information that they are collecting to find out. They are collecting information to find out what are non-U.S. people doing in the United States that may be money laundering here, maybe moving criminal proceeds here, but more likely is home country tax evasion. And they're collecting that information on that. So that is, I think, answering your perception and response question. And one of the things to get to the, to the clever things people might be doing out there, absolutely, in going after the Swiss bank situation, the bank's answers back were, we're in compliance with QI. We're in compliance with qualified intermediary. And the Department of Justice's answer back was, you manipulated what you're doing to make it look like you were in compliance with QI, and you used it to set up these clever structures to actually avoid QI and evade aid-assisted evasion of U.S. taxes. And the same analysis is going to apply when somebody finally looks at the kind of manipulations that are being done that you were talking about. So those are risky things. I mean, those are just risky things to do. And then I want to get back, although I wanted not to say this, I kind of feel compelled to. I mean, on the flight on the way down, I was both absorbing the result of the election, which was shocking to me, not what I expected, and then realizing that we had set this panel up 2 days after the election, and we were not really thinking about what's going to come next. This is a pitch for the panel in March, because I think we will have absorbed a little bit more about what the new administration will do. And you've got both branches now controlled by the same party, and I think you are going to see a different fundamental underlying philosophy to some of this that which in fact I would think would be more competition friendly, more putting U.S. banks on a competitive, better footing if you can do it in the current transparency environment. But I think there are two things that are kind of trends that you have to pay attention to anyway. Increased transparency, increased cooperation among countries, increased global view of compliance isn't going away. So if it's FATCA or CRS, the world is moving in those directions, and will continue to move in those directions, and the United States will have a hard time pulling out. We set it in motion. We said to participate in the global economy, we expect all of this, but to participate in the global economy, we're going to have to acknowledge and do some of that. The other thing is that the government, there's a permanent body of people who are the government, and they don't leave when administrations come and go. So once you get past the political level, political appointees of the government, the line people are moving forward in certain ways and will probably continue to do so. Not necessarily with regulations, but certainly with the way IRS examines things, with the way FinCEN gathers and uses information, with the access to the information FinCEN has by investigators and prosecutors, and with the prosecutorial discretion and initiative that a lot of prosecutors have. I don't think a lot of these trends are going away. I was privileged to serve as a presidentially appointed Senate confirmed person. The person who had my job and was also presidentially appointed and Senate confirmed under the prior administration before me, there's no light between what I did and what he did. I mean, I picked up on things he was already doing, and I went forward with them. And I would expect a lot of this area, the part of the government that stays, even as administrations come and go, will continue to move forward here. We have another question.
Thank you.
We got to actually, we're running out of time. I want to give space for perhaps one more question, quick one. And Mike, if you can address this one perhaps, and then with your final thoughts, because we're really running out of time. Brian, please.
Yes, thank you guys. Going back to the Bank of Nova Scotia subpoena, I'm just curious to say, well, if we're doing that, what would prevent other countries from essentially, putting something, a Bank of Nova Scotia subpoena in order in their home countries for our domestic institutions that are operating abroad? For instance, a city, where there's global locations all over the place. What would prevent them from subpoenaing Citi for people who are trying to evade and hide taxes or real estate purchases through our domestic financial institutions? And secondly, going back to, with, yes, our government changing over in 2 months, the administration, are we just essentially going to do away with transparency?
Lots of things in that question I'll try to do very quickly. What we are absolutely seeing, which is what I was trying to say before, is that the rest of the world is turning back to us and saying, you've beaten up on us for years and you've got to hold yourself to the same standard. That's absolutely what we're seeing. Okay. I understand. I've been called worse in the Swiss press. The Bank of Nova Scotia situation in particular, we don't have bank secrecy. Bank of Nova Scotia subpoenas are designed to break through the bank secrecy laws of another country. I think there are fewer barriers to another investigation, an investigation in another country getting access to information that's here, because we don't have data protection and we don't have bank secrecy in the ways that other countries have. And for the most part, you don't see Bank of Nova Scotia subpoenas come up in a situation where you've got mutual exchange agreements, treaties, where you can go government to government. So where there's, where in the absence of a Singapore treaty, might Singapore issue the equivalent of a Bank of Nova Scotia subpoena? But I would expect Treasury, the State Department, the banking authorities to say to the bank, give them the records, that we don't have that kind of barrier. I don't remember, there was a third part of your question about the change of administration. I don't know. It's very clear. It's very clear there are people in the Republican Party in key positions now, Senator Paul, who will look to roll back some of the transparency. I can't predict what will happen. I don't know what the next administration's priorities are going to be. Sorry.
Final thoughts, please, because we were running out of time.
Sure. Well, I think the prospect for true tax reform is higher than ever before, because all the red colors on all the houses and the White House. But if you want to address the issue of reciprocity and so forth, I think a lot of the U.S.'s sentiment is, if the world wants access to the U.S. financial markets, or if they want to denominate business in U.S. dollars and use a correspondent bank for a payment, or if a FIBA payment somehow for 1 second gets routed through a New York or Miami bank, regulators believe we have authority to supervise to do that. You got to follow our rules. That's their perception. Whether it's a bully word or not, I mean, it's all a matter of perception, right? But it's the U.S. financial market that's sought after by the world for security and the currency and so forth. Okay. My final thoughts are the consequences of the CDD. There's a continued monitoring aspect of that. So I see entities having to put out a form that basically says, in 2015, your legal entity, let's say your LLC, had this ownership percentage, blank, 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 filled in. And in 2016 or the next year, leave it blank and ask for a response. Did anything change or not? I think that will be a necessary exercise for you to meet the continued monitoring requirement of the new CDD rules. So I just wanted to mention that. I do think you're also going to see fiduciaries that the financial institutions are dealing with. They're going to be asking those fiduciaries for more information to get. I think that's a clear situation. And then where there are red flags, I think we'll start hearing more situations about closing accounts and so forth. I think that's the true reality. The one, to end on a good note, a covered financial entity and a legal entity customer, what isn't included? If you have any charity accounts for charities or non-for-profits, escrow accounts set up by lawyers, government accounts from bank holding companies also are exempt. And then there's this, a legal entity will be exempt to the extent that the private banking account for a non-U.S. person is already subject to FinCEN's private banking account regulations. I'm not quite sure what that means, but I think what they're saying is that if you're already collecting this information under your other rules, the enhanced due diligence, if you're already exceeding those other rules and you happen to meet this standard, then you're fine. It's just an exception that they decided to list. I think it's an excuse to say this isn't that burdensome. We're not asking you to do a whole new thing. We're just asking you to tweak it.
Mike and Kathy, thank you so much. I'll leave with this and we'll close for today. Number one, we'll continue to see the environment, like Kathy was saying, the political environment, how it affected all this. Number two, correspondent banking. If you remember, in December, we're having another panel to talk about CDD and foreign correspondent banking. Number three, there are a bunch of issues that are affecting financial institutions right now as they consider the CDD final rule, including what is event-driven. What is event-driven? Is that when you open up an account and you've had an account for so many years? Is that when you get a wire in? Is that an alert? Is it a high-risk review? What does event-driven mean? Including, how do you aggregate all this new information for CTRs, your training for your front and back lines, staffing areas for the bank, shifting areas, system considerations, and all that goes into the blend, which we will be talking more on FIBA on a quarterly basis. I want to thank the panelists for a great job today, despite of the technical difficulties. I want to thank folks who are here present and the people who are looking at this presentation online. Thank you very much.
Thank you.
Thank you.
You got